So the title of the talk is Linguistics for Lawyers and Anyone Who Needs to Hire a Lawyer. Let's begin with answering this question. What is linguistics? For the purpose of this presentation, it's important to recognize that linguistics is the science that determines what all human languages have in common, including sign language. And one of the best kept secrets about linguistics, especially for those that are thinking about how it connects to the law, is that highly selective law schools tend to admit students who are atypical, and very few attorneys study the law. And so think about majoring or minoring in linguistics if you want to get into one of those superior law schools. And we know that this is relevant by looking at specific cases. And the case that I want to begin with is a very famous murder trial from Texas, the Cullen Davis murder trial back in 1978. Cullen Davis, the reason that this trial is important, at least for this presentation, is that it's the first case ever where a linguist served as an expert witness. And the second point is that at the time this case happened, Cullen Davis, who was a very wealthy Texan who inherited wealth in oil and cattle, was the wealthiest defendant ever to stand trial for murder. As a result of that, he had more money and resources to devote to his defense than the prosecution had to go after him. And so it was really quite by accident that a linguist was hired in this case. For those attorneys who are watching this online, if you don't know this case and you've never heard of the attorney Richard Racehorse Haynes, who is pictured at the bottom right of this picture, he was not only a very flamboyant and effective attorney, but in this particular case, he used a brilliant strategy to introduce the linguistic evidence. It turns out that in the first trial, Cullen Davis was accused of attempted murder of his wife, featured here in the upper left-hand corner. Then, after that case, when he was acquitted, he was accused of attempting to hire a hitman to kill her and kill her new boyfriend. In that particular case, the FBI engaged in a wiretap, and the wiretap had a recording with a confidential informant who was working closely with the police. And it turns out that those recordings, there was a video recording and an audio recording that were edited, but they were edited in a way that might have implied that the FBI actually manipulated the data. And so Professor Schei, Roger Schei, was the linguist that was brought into this case. And Professor Schei did an extensive discourse analysis of the recordings that were edited. And when Cullen Davis put him on the witness stand, he asked him, Professor Schei, based on your research and your analysis, did Cullen Davis actually ask to have a hitman hired to kill his ex-wife? And the expert concluded, he said, no, I don't think so. Cullen Davis stopped, sat down. Let's put the prosecutor in a bind. Does he just let the jury see that? Or does he, in fact, pursue this? So Cullen Davis could have asked the professor, describe your research, look what you've done. But because he didn't do that, it was the prosecutor who had to pursue introducing the fact that the FBI had actually manipulated and edited the data. Very effective. Turns out that for this particular case, Cullen Davis wasn't convicted as well. Now, the next case that I want to talk about is one that I worked on. And it's a very different murder case that took place during the age of social media. And many of you are involved and active in social media. And it turns out the defendant, who is partially pictured here, was very active in an urban gang in a major East Coast city. And he had a very big social media presence where you could see him with guns, drugs. He had a picture with him with a fan of $100 bills, wore sunglasses. He was slender and a handsome young man. And it turned out that he met a young woman who lived a 3-hour drive away from him. And they were boyfriend and girlfriend for 3 years. She described him as exciting, even kind at times, but he had a temper. And that temper would flare from time to time. And after 3 years, she finally said, we can't continue. But they kind of did continue from time to time because he would sometimes show up at her place. Sometimes she would let him in. Sometimes she would send him away. Sometimes when she let him in, they would be intimate. And any psychologist knows that kind of reinforcement behavior is going to keep him coming back. Well, eventually, she met a new guy, a guy that lived close to her, church-going brother who had a good job, somebody you could build a future with. And it turns out that, on the night in question, he picked her up from work. She worked at a nice upscale restaurant. The restaurant closed. They got a pizza, drove back to her condominium. It was a 2-story condominium. It's around 10 o'clock at night. They go in. He goes upstairs to take a shower, and while he's taking a shower, the defendant knocks on the door. She lets him in, and he said, hey, I need to talk to you. And she said, no, you can't talk to me right now. I got company. You need to go. He said, no, you tell him to leave. She said, no, you need to leave. His temper kicked in. They argued. He pulls out a 9mm pistol, shoots her in the neck. She hits the floor. He goes upstairs, puts 8 bullets in the new boyfriend. He slumps to the bottom of the shower. He steps over her body, leaves, thinks they're both dead. She's not dead. Turns out she's still alive. She's shot in the neck. She can't speak, drags herself to a neighbor's, knocks on the door, open and shut, points out that it's the boyfriend, okay, who shot her, okay? This is a prosecutor's dream, right? Attempted murder, the witness is alive, ex-boyfriend, we got this, right? Now, this isn't Cullen Davis. This is a poor black man, had a public defender. And the public defender, was somebody that was working on the case, but it turns out that this young man was very concerned because the public defender was not behaving in a way that he wanted to pursue. So he asked the judge, Your Honor, can you get me a new public defender? And the judge denied that request. And so he said, well, if that's the case, I'm going to defend myself. Right? It's your right. Everybody in here knows that if you're brought before the law, you have a right to defend yourself even if you're not an attorney. It may not be the best decision. In this particular case, it was not the best decision. I had an opportunity when I was brought into the case to read everything about this case. And one of the heartbreaking things that I read was an honest statement that he made to the court about the fact that he hadn't led a perfect life. But even though he hadn't led a perfect life, most of the difficulties he had were at the hands of white people. And here he had a white judge, a white prosecutor, an all-white jury, and he wasn't expecting things to go well. And they didn't. They convicted him for murder, and he was waiting for a sentence and possibly a death sentence when a completely different set of circumstances unfolded. Unrelated to this trial, but during the course of this trial, it turns out that the judge and the prosecutor, along with other white officers of the court who were male, were exchanging racist and homophobic emails and pornographic material on their work computers using pseudonyms. All right? Now, I looked at this stuff. It was disgusting. I'm not an attorney, but that was disqualifying for me. That judge, out of the profession. That prosecutor, out of the profession. I don't know if they were out of the profession because what the appeal was, right, what happened was when the defendant realized what had happened, he said, wait a second, there's no way I got a fair trial. How could I have gotten a fair trial when the judge was racist? The prosecutor was racist. The prosecutor said things about me in the court that were racist, right? So he wanted a new trial. They brought in an appellate judge, and that appellate judge was trying to determine were the violations by the judge and the prosecutor during the course of the trial such that he didn't get a fair trial, right? It's a separate question as to whether or not they're racist. Their behavior during his trial was the thing that came up, right? So he asserted that it was a fair trial, but it was imperfect. And I want to point out as a linguist that it's important to appreciate that all trials are rituals. Weddings are rituals. Graduations are rituals. But trials are also rituals. When you go into the courtroom, the judge is wearing robes, right? They're not in business attire. I'm dressed a little too casually for court. I'm not dressed badly, but this is not how you want to dress for a courtroom, right? So the ideal scenario is a fair trial that's a perfect trial. That almost never happens. The judge asserted that this was an imperfect trial, but it was fair. A trial that, is perfect but unfair is a contradiction, and an unfair trial that's imperfect is a miscarriage of justice. And so when we're looking at those four possibilities, we want to ask another question that came up in this case, because the critical phrase that the prosecutor stated that the defendant reacted to was this one. He shot them both because he was a big city guy who said he had been disrespected. And what the judge concluded was no one would draw any racial inference from that statement. But when I read that, I thought to myself, well, the jury saw that he was black sitting in the courtroom. So why would you say that no? It's not necessary for the prosecutor to overtly make the statement that he's black, right? Also, in the courtroom, they had visual cues. So as a research scientist, I realized this is a testable hypothesis. And in order to test the hypothesis, I conducted a survey research with 137 Americans, 18 to 81, coast to coast. The only thing they have in common is they're native speakers of American English. Focus in on line 3, especially on the one on the right. Because the one on the right, without any visual cues, notice they're just looking at these sentences. They have no idea about my specific case. They think they're comparing 4 different things in a linguistic survey to see how would you characterize a welfare queen, a meth head, a big city guy, or a redneck. None of those are explicit about race, but when you look at the results, the highest histograms are for a low-educated gang member who's African American. No visual cues. Now, why is this significant? I thought about the fact that when he said he had an all-white jury, most of us have heard the expression, you're judged by a jury of your peers, all right? But the fact of the matter is, in the United States, you're judged by a diverse group of people with different sociolinguistic backgrounds. Those of you in the room, or any attorneys watching this on the internet, do you know where the expression, a jury of your peers, comes from? It's over 800 years old. It comes from the Magna Carta, 1215, Clause 39, when people lived in villages and feudal societies. At that point, you were lucky if your cousins weren't the ones that were judging you, okay? So when we think about the current situation that we're facing, we need to ask what people's linguistics backgrounds are when they get in the courtroom, all right? And for everyone here, and especially for the attorneys and judges that are watching, I have a question for you. Do you have an accent? Many well-educated Americans who are well-spoken and articulate proudly say they don't have an accent. And they're wrong. When people say they don't have an accent, what they mean is that the manner in which they speak doesn't cause a problem in their lives. It doesn't bring undue negative attention to itself. I'm most famous for a concept called linguistic profiling, where I was able to prove that people are discriminated against sight unseen based on their dialects over the telephone. They're denied housing, they're denied jobs, they're denied other opportunities if the person listening to you who offers goods and services determines you're an undesirable person. So the fact that we have people with different accentual backgrounds sets the stage for the linguistic secret sauce that we can use in the courtroom. If you think about diversity completely from a linguistic perspective, every racial and ethnic group in the United States has a percentage of the population that fits into these 3 categories. You're either a native speaker of Standard English. Standard English is not native. The people that grew up in the mountains in Appalachia, as well as many of my fellow slave descendants, speak with non-standard dialects, and the vast majority of immigrants to the United States came here speaking languages other than English. every linguistic event, and especially linguistic events in the courtroom, are composed of people who are introducing statements, people who hear those statements, they're on a specific topic, you are using a given language, there's a channel of communication, whether it's speech or if it's an affidavit, it's in writing, and there's the setting where this is produced, as well as the communicative event itself. This ethnographic component, when combined with looking at the linguistic diversity, can be applied especially in something like jury selection, because there are participants who are officers of the court or others who are in the courtroom all have linguistic backgrounds that intersect with the criteria that I just mentioned. A paralegal or an intern working on a legal team could also make some observations about sociological characteristics as well as cultural characteristics to see if there's linguistic compatibility between the defendant, the plaintiff, and others who are on the jury. The more linguistic compatibility, the greater the likelihood that you might have empathy for your client. There's another thing that we look at from a philosophical point of view in linguistics, and it comes from a field called speech act theory. In speech act theory, an individual who makes a statement may or may not be authorized to do that. So you're under arrest, or I sentence you to 10 years in prison. If that's not said by a police officer or a judge, it doesn't count. I'm able to produce that sentence grammatically, but the fact that I've produced it grammatically doesn't mean that I'm going to be able to arrest you. So I've extended this to discourse theory because what a judge writes has this impact, not just what they say, but what they produce. So in a legal context, there's a greater impact. So one of the most important things to me, as someone who served as president of the Linguistic Society of America, is that if attorneys decide to hire a linguist, be very careful and hire someone who has the skills for your case-specific needs. And my research has provided me with the opportunity to speak to Americans from lots of different backgrounds, lots of different walks of life. And there's one thing we all care about, regardless of ideological perspective. We care about fairness. And in the context of looking at linguistics and the law, and I've just scratched the surface on what linguistics can do for the law, we the people still yearn for that more perfect union with liberty and justice for all. Thank you.